Former Oregon Governor John Kitzhaber's son, Logan, was in a serious car crash near Lincoln City. Police say the 18-year-old's car sideswiped a motorhome on the 4th of July. Logan was flown to OHSU with serious injuries and later released. He has been tested for DUI with no conclusion yet. But what does it mean that police sought and received a warrant to draw blood for the test? McDaniel Reynolds of the Reynolds Law Firm, they specialize in DUI cases, joins us to answer that question.
The national trend, especially over the last 3 years, and frankly the safer option for a police officer in that situation, is to ask for a search warrant from a judge. And so to get a judge involved means that a judge is making a determination based on the evidence that an officer gives him or her, that it's more likely than not that there is evidence of a crime within that blood. When the officer provides that information to the judge makes that determination, then the search warrant allows an officer to obtain that blood for later use as evidence against that person.
Is blood drawn for the test, Dan, only if the person is unconscious?
If a person is taken to the hospital, in Oregon, there's not a breath test that's been deemed portable in order for an officer to take a breath test to a hospital, a breath test machine to a hospital. That would not happen in Oregon. So in Oregon, if there's an accident and a person is in the hospital, breath test is not an option. And so then the only other option available for an officer generally is going to be a blood test at that point.
And since not every accident is alcohol related, what would lead an officer to test for DUI?
The legal term is probable cause. What that means is that it is more likely than not that something has occurred. So more likely than not that there is evidence of a crime in the blood in this case.
How long does it usually take to get the results back?
Well, the State Police Crime Lab is backed up. It could be anywhere from 2 weeks to 2 months, depending on their availability to process the blood.
When people come to you, what is the one piece of information you wish they had known that most people don't know?
That .08 is not the final decision of whether or not a person is charged with a DUI. The state can go forward with a DUI well under .08. In fact, they frequently do. An officer's determination that's more likely than not that a person's mental or physical faculties are adversely impacted to a noticeable or perceptible degree by the use of alcohol, or in other words, that a person's not as sharp mentally or physically as they would otherwise have been. That's the standard to be arrested, and this is the standard to be prosecuted. So .08, if you're above that, is an easy way for the state to prove a DUI, but that just because you're below it doesn't mean that the state can't still proceed with a DUI against you.
McDaniel Reynolds of the Reynolds Law Firm, thank you for the information and for being with us.